Good afternoon. My name is Kim Stanger, and welcome to this presentation today. This is one of our continuing monthly webinars dealing with different compliance issues and other issues for healthcare providers. Today we're going to be talking about gifts to referral sources. After all, it is the holiday season and gifts come up frequently. We get lots of questions about this. So we're going to talk about today some of the relevant laws that apply. Then we're going to apply those laws to common situations involving gifts to referral sources, physicians, patients, vendors. Now we're going to be talking today particularly about gifts, not all the potential issues that those laws may apply to, but we're focusing just on the gift situation. If you have questions during the presentation, feel free to submit those using the chat feature, or you can shoot me an email offline. I'd be happy to respond to you offline. As far as written materials, you should have received a link that had the written materials along with the PowerPoint slides. If you didn't get that, just shoot me an email and we'll make sure you get those. Provided you a lot of materials that covering the stuff that we're talking about today, particularly some articles that I drafted on gift giving and other things. Also, guidance from the OIG dealing with giving gifts. I wanted to call special attention to the OIG's policy statement that came out late last year. I'll talk a little bit more about that but we provided you with a copy of that also. So make sure that you update your reading list over the next few days with that policy statement. When we're talking about gifts, what's the big deal? I mean, who cares? Is the government just the Grinch? Well, the government's concerned that if you offer gifts or other kickbacks to patients, potential referral sources, that it's not good. It could promote overutilization, and we want to protect the corpus of the Medicare Trust Fund. It could increase program costs. It could corrupt medical decision-making because maybe now you're making medical decisions not necessarily based on the patient's best interest, but whether or not you're going to get a gift out of the deal. It could result in patient steering and unfair competition. You may have a situation, according to the OIG, where rich people can give gifts so they get richer, and the poor, humble practitioner in a small practice can't afford to do that, so they continue to lose business along the way. So what did the government do in response? Well, they do what they always do, which is pass laws, including the Anti-Kickback Statute, the Ethics in Patient Self-Referrals Act, which is more commonly known as STARK, the Civil Monetary Penalties Law. In addition to those federal statutes, there are also state laws that you have to be concerned about, and you also have to be concerned about if you've got contracts or grant requirements, things like that, that may prohibit certain situations where you may give or receive gifts. Let's talk about those. First and most importantly is the Anti-Kickback Statute. The federal Anti-Kickback Statute says you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government health care program unless the arrangement is structured to fit within a regulatory safe harbor. A couple of comments on that. Note that this is an intent-based statute. You got to have improper intent. But the test for determining whether or not you've got improper intent is what's called the one-purpose test. That means the Anti-Kickback Statute applies if one purpose of that remuneration is to induce referrals, even if there are other legitimate purposes. So if one reason for giving that gift is to either reward or to encourage future referrals, then that is potentially a violation of the Anti-Kickback Statute unless you can structure your deal to fit within a regulatory safe harbor. Spoiler alert, there really is no regulatory safe harbor under the Anti-Kickback Statute that applies to gifts. Note that the Anti-Kickback Statute applies to any kind of remuneration, including gifts. Remuneration is very broad. It's anything of value. So anything of value could potentially implicate the Anti-Kickback Statute. Note that the Anti-Kickback Statute not only applies to the giver of the gift, it also applies to the receiver of the gift. So both can go down and both can go to jail because this is a criminal statute. Ignorance of the law is no excuse. So even though you thought that you were just being a good person by giving that gift, if you had improper intent, you gave a gift that is likely to induce referrals for items or services covered by federal health care programs, then guess what? You could violate the federal Anti-Kickback Statute. Well, what happens if you violate the Anti-Kickback Statute? As I mentioned, It's a felony. It's a crime. You can go to jail for up to 5 years in prison. You can also get hit up with a $25,000 criminal fine. You can get hit up with a $73,000 administrative penalty. That used to be a $50,000 penalty, but last year the government applied the cost of living adjustment and upped all these penalties. Now the current penalty is roughly around $73,000. In addition, you can get hit up with treble damages, and you can be excluded from Medicare or Medicaid. The government has indicated that if you gave an improper gift resulted in the Anti-Kickback Statute violation, then you have an affirmative obligation under the False Claims Act to self-report that, and the minimal amount of money that the government will accept to settle that is a $50,000 settlement. As I mentioned, the anti-kickback violation is also an automatic violation of the False Claims Act, thanks to the Affordable Care Act. What does that mean? Well, the anti-kickback statute is a criminal statute, but a violation of the False Claims Act is a civil statute, which means that the government has a lower standard of proof. You can be hit up with the additional penalties under the False Claims Act in addition to the penalties under the Anti-Kickback Statute, which includes penalties, used to be $5,500 to $11,000 per claim. Guess what? That's been doubled. That's now roughly about $10,700 to $21,500 per claim. You can also be subject to a qui tam lawsuit. A qui tam lawsuit is where you've got an employee or somebody else goes out and sues you on behalf of the government. They become a qui tam relator, which is kind of nothing more than a bounty hunter. And if the government recovers from you, then that qui tam relator gets a portion of those penalties that are imposed. That is the Anti-Kickback Statute. The Anti-Kickback Statute's evil twin brother is the federal Stark Law. To understand the Stark Law, it helps to understand a little bit about the background. In the late 1980s, early 1990s, the government was concerned because they were seeing a spike in referrals and payments for things like imaging, labs, things like that. The government says, well, why are we suddenly paying more for labs and imaging than we have in the past? The government looked at it and they concluded, well, what happened is you now have a bunch of physicians who've gone out and invested in labs and imaging, and therefore they're making these referrals to these entities that they own in order to order more tests and get more money. So Pete Stark said, well, we can put a stop to that, so they implemented the Ethics in Patient Referrals Act, or Stark. Stark says that if a physician or their family member has a financial relationship with an entity, the physician may not refer patients to that entity for designated health services, and if there is an improper referral, that entity may not bill Medicare or Medicaid for such designated health services unless that arrangement has been structured to fit within a regulatory safe harbor. Okay, now Stark doesn't prohibit the gift. That gift, by the way, would create a financial relationship that would trigger Stark. Stark doesn't prohibit the gift. Stark just says if you're going to create that financial relationship, if you're going to give that gift, then you can't make physician, you can't make referrals over to that entity, and entity, you can't bill Medicare or Medicaid for those services that were referred per an improper referral, unless you structure the deal to fit within a regulatory safe harbor. We'll talk more about those in a minute. Well, what are the penalties for a Stark violation? Unlike the Anti-Kickback Statute, this is a civil penalty, not a criminal penalty. But at the very least, you can't get paid for services that were provided per an improper referral. If you did receive payment, you've got to report and repay that that money you received improperly within 60 days. If you don't, you can get hit up with civil penalties. That's been up now to $23,000 per claim if you fail to repay within 60 days. If you try to come up with a scheme to circumvent Stark, and the government doesn't like it, they can get you up with penalties of $159,000 per scheme. If you've got a Stark Law violation, there's a good chance you've got an anti-kickback violation also, which means that you can get hit up with those criminal penalties as well as the False Claims Act liability. Now remember, Stark, unlike the Anti-Kickback Statute, the Anti-Kickback Statute is very broad, applies to anybody. Stark only applies to referrals by a physician, and it only applies to referrals by a physician to entities with which the physician or their family member has a financial relationship. So you only have to worry about Stark if you're dealing with physicians, MDs, DOs, oral surgeons, the others that are up there. Stark anti-kickback statute applies to referrals for any items or services that are payable by federal health care programs. Stark only applies to certain designated health services payable in whole or part by Medicare or Medicaid, which are generally those items that are up there on the screen, particularly a lot of the services that are provided by hospitals. A lot of the stuff that's done in just physician offices is not necessarily prohibited by Stark, so you may be able to offer a gift and not violate Stark, but you've got to be concerned about the anti-kickback violations. All right, let's talk now about the civil monetary penalties law, which is the third prong in Satan's trifecta of these fraud and abuse laws. The civil monetary penalties law is kind of this catch-all statute. It prohibits certain types of specified conduct, including offering, soliciting, or giving or receiving remuneration to induce referrals. That's just the anti-kickback statute. Or offering inducements to program beneficiaries if you know or should know that the remuneration is likely to influence the beneficiary to order or receive items or services payable by a federal or state program, and that's provided by a particular provider. What does that mean? That means that if you're offering Medicare or Medicaid beneficiaries gifts, and you know that those gifts are likely to induce their ordering services or receiving services that are payable by Medicare or Medicaid, you've got a potential civil monetary penalties law problem. In addition, as I mentioned, under the Affordable Care Act, if you've got a violation of any of these statutes, the Anti-Kickback Statute, Stark, or the Civil Monetary Penalties Law, the Affordable Care Act imposed an obligation that you've got to report and repay within 60 days. If you fail to do so, that's a violation of the Civil Monetary Penalties Law, and you can get hit up with additional fines or penalties. The fines or penalties for violations of the Civil Monetary Penalties Law range from anywhere from $2,000 to $73,000. It varies depending on the type of conduct involved. In addition, you can get hit up for certain items for treble damages, denial of payment. You've got an obligation to repay amounts. Improperly paid, you can be excluded from the government programs and get hit up with liability under those other statutes. If you've got a violation of any of those other statutes, then it's probably going to be a violation of the False Claims Act, which triggers that obligation to report and repay within 60 days. You can get hit up with the additional fines and penalties under the False Claims Act. All right, those are the federal statutes we've got to be concerned about, but you've also got to be concerned about your own state laws, because most state laws have their own version of an anti-kickback statute. Some states are limited to the anti-kickback statute only applies to items or services that are payable by, Medicaid program or state-funded programs. Some states' laws, they have anti-kickback statutes that are more broad, that apply to any payer situation. For example, I happen to be in Idaho today. Idaho has a state law that prohibits offering any kind of kickbacks for any kind of referral in healthcare, not just program or government program business. Some states have their own version of the Stark law that prohibits referrals to entities with which you have a financial relationship unless you satisfy certain requirements. Some states also have disclosure laws that require you to disclose financial relationships. Almost all states, as part of the Medical Practices Act, have fee-splitting statutes that prohibit you from, or providers, physicians, from splitting any fees or offering any gifts or rebates in exchange for referrals. There may be other laws out there. The bottom line is, don't forget your state laws. That may also come back to haunt you. All right, those are the laws. Let's talk about applying those to certain situations. Let's talk first about gifts to referral sources. The OIG has made it clear that in some industries it is acceptable to reward those who refer business to you, right? You always do that. That's just good marketing. That's just good salesmanship. You always do that. But you can't do it in the healthcare context. In the federal healthcare programs, paying for referrals is a crime, including the anti-kickback statute. Those gifts to referral sources, other referral sources may be other providers, whether they're physicians, hospitals, groups, whatever. Could be other payers, could be vendors, it could be patients. Any of those are potential referral sources. What kind of gifts might trigger it? Well, cash, could be gift cards, gift baskets, wine or alcohol, that's a big one this time of year, could be free trips, it could be tickets to events, whatever. Any form of remuneration, anything of value that you're giving to those people potentially implicates these fraud and abuse laws, particularly if there is an intent to induce or reward referrals. Because if you've got that improper intent, hey, you've probably got an anti-kickback statute violation. That anti-kickback statute is going to apply if you offer, give, solicit, or receive remuneration. So if you're out there just trying to get a gift or trying to get something, remuneration from a person in exchange for your referrals, hey, that's a violation also. It applies to both the giver and the receiver. It applies, so first you've got to have an offer, give, solicit, or receive remuneration. Next, one purpose has to induce referrals. Again, that's kind of difficult to disprove. How do you disprove that, no, I gave that gift because that guy's just really a nice guy and the fact that he sends me a lot of referrals has nothing to do with it? That is a difficult standard to disprove. Third, it has to be for items or services covered by government health care programs. The federal anti-kickback statute only applies to items or services that are covered by federal health care programs. So what you may say is, well, okay, well, I'm not giving the gift for federal health care program referrals. I'm only giving the gift for referrals for the private pay business. So that's okay, right? Well, you're going to have a burden of proof in that situation. That's going to be hard to satisfy. How do you convince the government that, no, I really wasn't giving the gift for his federal program business. I was just giving it for the private pay business. How do you segregate that? Even if you're only getting referrals for federal program or for private pay business, the government has also said, hey, we're concerned about relationships or financial arrangements where you carve out the federal program business, so you're giving kickbacks for the private pay business, but you're not giving it for the federal program business because, you know, we can't really distinguish between the two, and therefore if that person is also sending over federal program business, really your gift is to induce the referrals for the federal program business as well as the private pay business. So there's no free pass on that. Be very careful about trying to carve out federal program business because it may not work in the long run. Of course, if that referral source never sends you any federal program business, then maybe you're okay, unless your state law prohibits it. Note that the anti-kickback statute does not have an express de minimis exception. So theoretically, anything that you provide a value, that has value, could trigger an anti-kickback violation. But the Office of Inspector General, which is the police that enforce this type of stuff, has said that the anti-kickback statute may apply to soliciting, accepting, or offering a gift or gratuity of more than nominal value to or from those who may benefit from a physician's practices referral federal health care program business. So if you're going to give something of purely nominal value, you're probably going to be okay. The problem is we haven't got any guidance under the anti-kickback statute for what is nominal value. You know, what is the dollar amount for nominal value? We'll talk in a few minutes about the Civil Monetary Penalties Law, where the Office of Inspector General has defined nominal value as $15 per gift or $75 in total of gifts to the patient per year. I suspect that that same standard would probably apply in under the anti-kickback statute, but we haven't seen anything specific from the government applying it that way. So what's the bottom line when you're talking about gifts to referral sources? Well, if you're dealing with government program referral sources who are sending government program business to you, you got to beware of the anti-kickback statute, especially if that gift is of more than nominal value. If that referral source is only sending private pay business to you, well, it's less risky, but there's no guarantees because you also got to be concerned about state law. You've also got to be concerned about perhaps contract provisions in there. All right, let's talk next about gifts to referring physicians, specifically physicians now. We're talking about physicians. Remember, the anti-kickback statute still is going to apply if one purpose of the gift is to induce referrals for items or services payable by federal health care programs. In addition, If you're dealing with physicians or physician family members, you got to be concerned about Stark. Stark applies if the gift is to a physician or a physician's family member, to or from them, and the physician refers designated health services payable by Medicare or Medicaid to the entity, unless you've structured the deal to fit within one of the regulatory safe harbors. Unlike the Anti-Kickback Statute, there is no improper intent requirement in Stark. It doesn't matter whether you've got good or bad intent. The question is whether or not you gave that gift. If that gift constitutes remuneration, Stark is triggered, and you need to structure the deal to fit within a regulatory safe harbor if there are going to be any referrals for designated health services. Stark generally doesn't apply to referrals for private pay business, but you may have problems under your state law, so make sure you check that. Now, if you structure those gifts to fit within one of the Stark safe harbors, then you're okay, but you need to satisfy all the elements of the safe harbor. For example, Stark has a safe harbor that applies to bona fide employment arrangements. So if you want to give a gift to your employee, well, that's probably going to be okay as long as you structure it to fit within the safe harbor. It's really easy generally to do. Basically, the Stark safe harbor for employees is that it just has to be a bona fide employment relationship. It's not just kind of a sham as a way to funnel money to them without expecting the person to do anything. Assuming you've got a bona fide employment relationship, the employment has to be for identifiable services, and the amount of the remuneration under the employment has to be consistent with fair market value and is not determined in a manner that takes into account the volume of value referrals, and the remuneration is otherwise commercially reasonable. So you've got an employee, you want to give them a jacket or something else because they're a really good person, you can go ahead and do that as their employee so long as that gift doesn't push the overall compensation that you're providing to that employee above fair market value, and you're not limiting those gifts to their referral patterns. So you're only going to give that gift if that employee is generating a whole lot of business or making a whole lot of referrals, designated health service referrals to you. Now note that this exception only applies to bona fide employees. If you're dealing with independent contractors, well, in that situation, the compensation formula has to be set in advance, and you can't modify that within a one-year period. So if you try to pay an independent contractor or give the independent contractor a gift outside and it's not covered by that independent contractor professional services agreement, well then that wouldn't work because the compensation wouldn't be set in advance. So you would need to look for another safe harbor that might apply in that situation. Stark also has a safe harbor that applies to non-monetary compensation if you're providing items or services that are not cash or cash equivalents, that the aggregate value is less than, it used to be $300 a year, but it comes up with a CPI adjustment. I believe for 2017, the amount now is $398 per calendar year. It's not determined in a manner that takes into account the volume or value of referrals or other business generated by the referring physician, so it's not a situation where you're only given your high referral sources this gift. It can't be solicited by the physicians or the physician's practice. They can't come knocking on your door and saying, hey, it's December 24th, we would like our gift, please. It can't violate the Anti-Kickback Statute, which means that you can't offer that gift with the intent to induce referrals. In addition to that non-monetary gift, that individual non-monetary gift, the Stark also allows you to provide one annual staff appreciation event if you have a medical staff. So, for example, if you're a hospital, you could provide staff members, your medical staff members, with this non-monetary compensation up to $398 per year. In addition, you can also throw them a big party once a year, that staff appreciation event. If you are going to give out gifts as part of that big event, then you have to count that against that $398 limit that you can provide for the non-monetary compensation. If you have a situation where you find out at the end of the year, oh my goodness, so we forgot that we gave this guy a jacket, but we also gave this guy something else, and it pushes you above that $398 limit. They amended Stark recently to basically have a mea culpa situation, that if you find out you went over, as long as you didn't go over more than 50% of that limit, and the physician repays or returns that excess amount to you within a certain period of time, then you can go on your merry way and you'll be fine. STARK also has a separate exception that allows you to provide incidental benefits to members of your medical staff. It applies to hospitals and other entities with a bona fide medical staff to fit within that safe harbor. You can only give items or services that are not cash or cash equivalents. It has to be used on the hospital's campus. So, for example, it might be free meals, things like that, offered to all members of the medical staff practicing in the same specialty without regard to referrals or business generated between the parties, so you don't make it only provided to your big referral sources. It can only be provided during periods when the medical staff members are making rounds or engaged in other services that benefit the hospital or its patients. Generally, that means that you give it to them so that they use it while they're there at the hospital, not something that they can go home and use or use in their independent practice. It has to be reasonably related to the provision of services at the hospital, and the value has to be less than $33. That may have gone up this past year. I didn't check on it, but it has to be adjusted annually per CPI. And again, that gift that you're providing, that additional item you're providing, cannot violate the Anti-Kickback Statute, which means that its intent is not to induce referrals. If you're a physician and want to make a charitable contribution to your 501c3 hospital or its foundation, STARK has an exception that allows you to go ahead and make those types of charitable donations. All right, that is talking about gifts to physicians. What about gifts to patients? Well, the Anti-Kickback Statute still is going to apply because those patients are referral sources. And if you're offering gifts to induce or reward referrals from those patients because they came to you, they brought their business to you, then that is potentially an anti-kickback violation. If that patient happens to be a physician who refers designated health services or one of the physician's family members, then it can also violate STARK, but more specifically, the one you need to be most concerned about is probably the Civil Monetary Penalties Law. The Civil Monetary Penalties Law, again, applies if you know or should know that the remuneration or that gift is likely to influence the beneficiary, a Medicare or Medicaid beneficiary, to order or receive items or services payable by federal or state programs from a particular provider. Now, the OIG has given us some guidance when it comes to the Civil Monetary Penalties Law, or CMPL, about what is or what is not an acceptable gift. Specifically, they've issued an advisory opinion in which they said that the OIG has interpreted the CMPL to permit Medicare or Medicaid providers to offer beneficiaries inexpensive gifts other than cash or cash equivalents or services without violating the statute. For enforcement purposes, an inexpensive gift or services are those that have a retail value of no more than, used to be $10, but last year they upped it to $15 individually, and no more than, used to be $50, but last year they upped it to $75 in the aggregate annually per patient. So if you want to give your Medicare or Medicaid beneficiaries a gift, just make sure that that gift you give them is no more than $15. Not a cash equivalent, and make sure that if you give multiple gifts to a particular patient, that the aggregate value of those gifts don't total more than $75 per patient in the year. Okay, so that's the general rule for gifts to patients. I should mention that there are some other exceptions under the Civil Monetary Penalties Law that might apply if there's demonstrated financial need, or that for certain, you can give the patient certain things for preventative services, things like that. I'm not going to go into those today because we're really talking about gifts, kind of the holiday type gifts. Well, what about receiving gifts from patients? Is that okay? Well, I suppose in some circumstances it could be a STARK or anti-kickback statute if that patient also happens to be a recipient of referrals, but most of the time it's just dealing with the garden variety patients. Gifts from patients generally don't trigger those federal fraud and abuse laws, but you may have ethical concerns about receiving those gifts. Specifically, the AMA ethics opinion, they did issue an opinion dealing with gifts from patients. The bottom line is it's not a hard and fast rule, but you got to be concerned about receiving gifts if it's going to affect your medical decision-making process or interfere with the integrity of the patient-physician relationship. Specifically, they've said there's no definitive rules to determine when a physician should or should not accept a gift, No fixed value determines the appropriateness or inappropriateness of a gift from a patient. However, the gift's value relative to the patient's or the physician's means should not be disproportionately or inappropriately large. So you don't want that patient giving away their house to you when that's the patient's only house. One criterion is whether the physician would be comfortable if acceptance of the gift were known to colleagues or the public. All right, let's talk about gifts from vendors. You have that drug company or equipment manufacturer. They want to show up and give you or your staff gifts at the holidays. Could be trips, could be equipment, could be free supplies, meals, CMEs, sham services arrangements. Anything of value potentially implicates the Anti-Kickback Statute if it's done to induce referrals for items or services payable by federal health care programs. So if that vendor is providing an item or services that's payable by federal health care program, you may refer business to that vendor. We've got to be concerned about the Anti-Kickback Statute. Again, the government has suggested that nominal gifts likely would not be challenged. So it's just a question of, well, what is nominal? We really don't know. Probably that $15, $75 limit, probably a fairly good guide, but we don't know for sure. Remember, STARK applies if the physician refers patients to or orders designated health services from the giver. So if you've got a vendor who is actually a supplier of designated health services, STARK could be implicated. So you would want to make sure that you structure the deal to fit within a regulatory safe harbor. If you couldn't do that, you probably don't want to give the gift because it's going to preclude that physician from making referrals. What about free drug samples? In the OIG roadmap, which I provided to you, they stated that many drug and biologic companies provide physicians with free samples that the physicians may give to patients free of charge. On the other hand, if you want to charge the patients for that, well, then you are suddenly getting benefit for that, right? You're getting money. You're getting the difference. So if you are doing that, that would constitute remuneration, and that would be illegal. That could create lots of problems for you. If you're just going to pass on the free items to your patients, probably going to be okay. If you're actually going to charge them for it and you got the benefit, not so okay. The AMA has given us guidance when it comes to gifts from vendors. They've stated that to preserve the trust that is fundamental to the patient-physician relationship and public confidence, physicians should decline cash gifts in any amount from an entity that has a direct interest in the physician's treatment recommendations. Decline any gifts for which the reciprocity is expected or implied, meaning that, hey, we'll give you this gift if you send us back referrals. You shouldn't accept an in-kind gift for the physician's practice only when the gift, or you may accept an in-kind gift for the physician's practice only when the gift will directly benefit patients, including patient education, and is of minimal value. In addition to the AMA guides, the pharma industry, the AVAMED, they both published a code of ethics provisions that talk about when it's okay for the industry, the pharma industry, the manufacturer industry, to provide gifts to vendors or to physicians or physician offices. Make sure that you're aware of those situations and those guidance. Remember, too, that if you are a physician receiving gifts from these types of vendors, that you have an obligation to report those gifts under the Federal Sunshine Act. That says that medical device and pharmaceutical companies must submit annual reports to CMS identifying payments or other transfers of value made to physicians or teaching hospitals. It excludes payments of less than $10 individually or $100 aggregate annually, certain educational materials and in-kind items for charity care. That report that the manufacturers have to submit has to include the name or address of the physician. So if your patients want to find out whether or not you are a recipient of that, they can log on to the government's website and they can get information so that they can evaluate whether those gifts may affect your medical decision making. All right, so in summary, remember that anytime you accept government money or participate in government programs, there are always strings attached, including those federal fraud and abuse laws that limit or prevent your gift giving. Gifts to or from entities that are not involved in government programs are less risky, but there's no guarantees. You got to be concerned about your state laws. You got to be concerned about ethical rules. You got to be concerned about maybe contract requirements that you might have. On the other hand, gifts to or from entities involved in government programs may implicate the Anti-Kickback Statute, STARK, and the civil monetary penalties law. You want to make sure if you're dealing with government programs, you're giving a gift to referral sources or receiving a gift from a provider of those services, you need to consider your potential liability and their potential liability under these federal statutes. Before giving or receiving more than a nominal gift, ask yourself, is the recipient a referral source for items or services covered by government programs? If you do, the bells ought to be going off, and you're thinking anti-kickback, civil monetary penalties law, STARK if it's a physician. That could be referring providers or patients who are government beneficiaries. Assuming that they are dealing with federal program beneficiaries or federal program business, ask yourself, well, why am I giving the gift? Is it to thank them for past referrals of their business or to encourage future referrals or business? If so, hey, that means you've got an anti-kickback violation on your hands. Why are you giving this gift to this person and not others? Is it because this recipient is a good source of business and you hope to receive future business as a result of the gift? If so, then, hey, that's done for an intent to induce referrals and probably an anti-kickback violation. Remember to beware your state laws. They may be broader than the federal laws because they may apply not only to government programs but also private payers. Common state laws, again, include beware your own state anti-kickback statute, mini STARK laws, fee-splitting statutes, or the like. Red flag situations. If any of these situations arise, you got to be concerned. Gifts to or from sources who refer government program business, or gifts to program beneficiaries, gifts to physicians who refer designated health services that are payable by Medicare, or gifts to their family members. Gifts based on referral patterns. For example, the gifts are only given those who refer business, or bigger gifts are given to those who refer more business. If that's the case, the gift is probably related to and intended to induce or reward referrals. Gifts to patients who receive significant services, or gifts that are given shortly after significant services were provided. All of those are situations which tend to suggest that, hey, the gift is offered not just out of the charity of your heart or your kindness or the Christmas spirit, but it's actually offered in order to induce or reward referrals. When it comes to dealing with these situations, an ounce of prevention is worth a pound of cure. Make sure you've got appropriate compliance plans in place that address these situations. You should develop a gift policy as part of your compliance program. It should include limits on gift giving, require the compliance officer to review before giving or accepting a gift of more than nominal value, which presumptively is $15. You should confirm the gifts received belong to the entity, not the individual. That lessens the risk that a particular individual gets that and makes their decisions based on the gift rather than a legitimate concerns either for patient safety or, quite frankly, the best interests of the entity. Any questions about the gift giving should be directed to the compliance officer. You must report suspected violations to the compliance officer, and violations may be subject to appropriate discipline. You should implement a method to track gifts to patients or referral sources for involving federal health care programs. Specifically, make sure that you aren't giving gifts that are more than $15 per individual or $75 aggregate per the civil monetary penalties law, or probably the anti-kickback statute. If you're giving gifts to non-monetary compensation to your physicians on your medical staff, make sure that the aggregate's not exceeding $398 per year. You should train your staff on the policy and document that training, so if there is a violation, the government comes in, you can at least point to a employee who went rogue, and contrary to your policies, that may help you protect you from at least going to jail. If you identify significant non-compliant gifts, well, you may have False Claims Act liability. You may have an affirmative obligation to report and repay. It may prohibit you from making referrals to that entity until the situation is resolved. The bottom line is consult with your attorney if you think you've got a problem. As far as additional resources, the government has a very helpful website dealing with all things compliance, including its Compliance 101 series, which are a series of webinars and other materials that teach you about compliance issues. The government's issued a number of compliance program guidances depending on what your particular segment is, whether you're a hospital or physician or others. They've given advisory opinions dealing with gifts. There's special fraud alerts, blah, 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 lots of other stuff out there. Or you can just call me if you have questions. Hopefully this has been helpful. It might be a good refresher, a time to sit down with your staff when you're going through the holiday season, making sure that you are giving and receiving gifts in an appropriate manner that isn't going to give either you or the recipient in trouble with the government. If you have any questions, feel free to give me a call. Thank you very much, and hope you have great holidays.